Lesson 3, real property issues. Let's do scenario 1, property valuation. So we have 5 parts to our scenario on property valuation. Put our recording on pause, take 15 or 20 minutes, read scenario 1, and then answer the questions by selecting what you think are the best answers. And then when you've completed all 5 parts, then return to our video presentation and we'll go through the suggested answers. Okay, let's continue with our scenarios and the suggested responses. Scenario 1, part 1. So with scenario 1, part 1, the appropriate responses are 1, 2, 3, 4, 5, and 8. Talking to your seller, potential seller, prospective seller, these would probably be the more important things you should be discussing with them. 1, the different properties that are comparable properties in the neighborhood that are either on the market or have sold. You might want to also talk about 2, the types of listing agreements that On Track offers potential clients, and there really aren't that many. There's the exclusive right to sell, which is going to be 90% of the listings that you give, with maybe 99% of the listings you'll have with private sellers. The only time you're going to do an exclusive agency listing might be on a commercial property and might be if you're working with a builder. But it sounds like a good thing to talk about. 3, similar houses in the neighborhood that are currently for sale or have recently sold. Very similar to number 1. That's the same idea. 4, agency representation issues. Very important when you're first meeting a seller or a buyer that you discuss the difference between client relationships and how that's formed and customer relationships and how those are formed. Obviously, a client relationship would be a listing agreement or a buyer brokerage agreement. That's when you're going to represent that principal as their agent and then owe them fiduciary duties. Or if you're just going to work with a buyer customer, then you would explain what non-agency means. But sellers are always going to be your clients, so there's not much to really discuss with agency representation. You're going to be their client. You are with all sellers. The 5, we want to remind the seller of their disclosure issues and responsibilities and duties. And probably this is a good time to bring up the property seller disclosure form, which will be those 23 items of disclosure, property disclosure, that all sellers, virtually all sellers, there are some exceptions, virtually all residential sellers are going to have to sign. Or explain to them why they don't have to sign one if their property is one where the seller is exempt. And an example of that might be a property that hasn't been lived in before. Nobody's ever taken possession of it. Then you wouldn't have to do a seller disclosure form. Maybe a builder's property, or maybe it was a foreclosed property. 8, you definitely want to find out all the owners of the property, all the legal owners of the property, because they're going to have to sign all the documents. Scenario 1, part 2, our better answers are 2 and 4 in helping them determine the value of the property. We might to consider using the cost approach, since there don't seem to be any comparables in coming up with value. 4, we might try to widen our search out of maybe the subdivision we were looking at. Maybe we go to other subdivisions in the area till we finally find a comparable. Rarely are you ever going to do the cost approach on a seller's property, on a residential seller's property. That's probably beyond, while that sounds good, that's probably not going to happen. You're going to find a comparable somewhere, or hire an appraiser, I guess, to do the cost approach, because they're pretty tricky. Not a lot of residential agents know how to do a cost approach that I would depend on. Scenario 1, number 3, we come up with an opinion of value. Apparently, this agent did do the cost approach using cost manuals, which 99% of the agents have no idea what those are or how to use them if they did. But anyway, in our scenario, in La La Land here, that's what we use to come up with the value of the property. And now she's got some offers. Full price offer, and then another that's actually $5,000 over full price offers. So how should we respond? Dawn says, what should I do now? So in advising our seller on what she should do, probably number 2 would be the best. We'll give her options. She can accept either of the offers and then go through negotiating on either of them. She can reject both offers and sort of start anew if she wants to. So she can either start negotiating on both offers, which typically is what you're going to do, or you're going to begin negotiations on just one of the offers, or you could reject both offers. It's okay to negotiate on more than one offer. Just don't accept more than one offer. Negotiating is fine, but don't sign the contract on more than one, or you're going to have yourself probably some issues. So she looks at the 2 offers and it's all the different terms and conditions of them, and suggests she thinks that the full price offer is the better offer, but she's going to make a counter offer on that and just negotiate on this one here, and she's going to make a counter offer that's $3,000 above the asking price. What information about the buyers might be helpful to know before Dawn makes her counteroffer of $3,000 above asking price? Well, probably 2, 5, 6, and 8. 2, let's find out if our other buyers are entertaining any other properties, because if we push them too high, they may just walk away from ours and go buy another one. 5, let's take a look at the time frames involved in negotiating the offers, and whether or not they're under if they're under some time-sensitive pressure to negotiate. If they are, that's good for us. That's good for the seller. Okay, if they have all the time in the world, then maybe pushing them $3,000 above list price might not be a good idea. Look at the financing options. Are they all cash buyers, or do they have to get financing? That's going to affect the more money they pay for the house, the more it's going to affect their ability to finance the property. If it's an all cash buyer, that's fine. If they've got the money and they can do another $3,000 and do it all cash, that's a good thing for us to know. And then 8 would be another good answer. Whether or not they have a property to sell in order to be able to buy Dawn's house, because they'll probably make that as a contingency. So no matter what they offer on their property, whether it's full price or above full price, if they accept her counter offer above full price, we need to know whether or not there's going to be that contingency upon the sale of their house. That could be a stumbling block to everything. So she presents her counteroffer, and while the buyers are considering this counteroffer, $3,000 above list price, we get an offer that comes in that's $10,000 above the asking price. What should you do now? Well, first celebrate, and then your best response is present the new offer immediately and see if she wants to just same options as before. Do you want to keep negotiating on both, if possible, or just one? Or do you want to reject both of them? You still can reject all of them if you want to. So, but the big thing you've got to do is when that new offer comes in, you have to present it. You can't tell Dawn, well, Dawn, you've already negotiating on another contract, which hasn't been accepted yet, so you can keep negotiating on that. You don't really have a contract at this point. But the big thing is you need to present that offer. So continuing on with our chapter, we have another key term matching exercise in this particular lesson. So we'll continue on. Key term matching, number 1. What do we call interference with the quiet enjoyment of land from something outside the property, that would be considered a nuisance. Anything outside the property that affects an owner's, quote, enjoyment of the property, full use of the property, could be considered a nuisance. Water rights of a landowner whose property is adjacent to a lake or contains a lake. Those water rights, when they're by a lake or an ocean, are considered littoral rights. Think of L for littoral and L for lake. Your rights to water bordering lakes or oceans means that your use of the property of your property can only go to the high tide watermark of either the lake or the ocean if there's tides. Even though you might own the property underneath the ocean or lake, you can only enjoy it or use it or control it to the high tide watermark. The rest is usually controlled by a state waterway or by maybe a homeowners association. The physical object intruding onto a neighbor's property, often due to a mistake regarding the boundary lines of the property, that would be an encroachment. The best example of encroachments would be probably fences. Typically, when people put up fences, they put them right on top of the property line, which means that the fence posts are actually encroaching. Half of the fence post is encroaching on somebody else's property. That's typically what the mistake what people make when they put the fences up. Make sure that your entire fence and posts are within your boundaries of your property, or they'll be encroaching on your neighbor's property. And that may cause them a problem when they go to sell the property, and a survey reveals that. For a temporary, revocable, non-assignable permission to enter another's land for a particular purpose is a license. So a license is where an owner can give a revocable permission to a person to use their property for a specific purpose, maybe for a specific period of time, and then that person you gave permission to would lose the right to do that. And it's non-assignable. The person you give that license to can't assign it to somebody else. An example might be, I have a large farm and might give a friend of mine a license to hunt on my farm. When I didn't want him to hunt anymore on my farm property, I could simply revoke his license. He'd no longer have the legal right to go and do that. And certainly during the period of time that he did have the legal right, he couldn't assign it to another hunter, a buddy of his, and would have the right. I can bar that person they assigned, my friend assigned his license to. 5, the water rights of a landowner whose property is adjacent to or crossed by a river. These would be riparian rights. Riparian rights are a little different than littoral rights. Riparian rights are for riparian, are for river. Basically, when you have a river running through your property, we have to determine whether it's navigable or unnavigable. If it's navigable, you only can control the property to the water's edge. Even though you have title to the river bed underneath, as long as it's being used from navigable waterways, you can't control anything on the waterway or below it. So you can own it, but you can't control it. With non-navigable rivers or streams, then you actually do own and control the property underneath the river or non-navigable river or waterway. You can't stop the flow of water now, but you do retain your ownership rights. A right that goes along with ownership of real property, usually transferred with the property, but may be sold separately. That's an appurtenance. And anything that goes along with the sale of property is considered an appurtenance. Sometimes appurtenances are good, sometimes they're not. The big thing is, Mr. Buyer, make sure you know all of the rights that are pertinent to that property, because some of them you may not want when you have your closing. And a pertinent would also include a lien or an easement, and that would go along with the sale of the property. So if you're not on board, the lien that's going to go along with the property, like a mortgage lien, or you're not good with any encroachments on the property, you better not close on that deal, because they're going to go along with your property. So make sure that any outstanding liens that can be dismissed are. Some liens can't be dismissed. The tax lien, for instance, you can't just dismiss that. That's going to go along with the property. But a mortgage lien you could. So the way you do that is you have the previous owner pay it off. 7, an item of personal property attached to or closely associated with real property in such a way that it becomes part of the real property. Well, those are fixtures, and a fixture is anything that was once personal property, but the owner has attached it in such a way that it becomes permanent to the dwelling, and therefore it becomes part of the real estate. And therefore, when the property is transferred, it goes along with the property. Don't have to make a separate provision for it. It goes along because it's attached to real property, becomes part of the real property, and deeds, as we know, convey anything that is defined as real property. A right-of-way giving persons other than the owner access to over real property for a particular purpose. So this would be an easement. An easement is simply the right that someone has to use, if you will, across somebody else's property. If you want to use the term right-of-way, that's okay too. An easement might be, I have a property, and you live next door to me, and you want to go across my property as a shortcut to a road, and I would grant you an easement to do that. Now, when I grant you the easement, a couple things happen. Number one is when that easement is granted, magically, mysteriously, and you don't even know it, your property has become the dominant tenement to that easement, my property the servient tenement. And that's important, because if I should decide sometime in the future, I don't want you going across my property, I can't unilaterally stop you. I have to have your permission in order to terminate that easement. If you don't want to terminate it, it stays on the property, and I have to maintain it for you. So giving easements across your property is an important decision to make. So don't make it lightly without good legal counsel. An unlawful physical invasion of property owned by another, that would simply be a trespass. That's the opposite of a license. A license is where you give people permission to come upon your property for a particular purpose. Of course, an easement is a permanent right that they have to go across your property. A trespass is any time individuals use your property without any permission. And therefore, you may have to call the police to get rid of trespassers. A hold or claim that one person has on property another to secure payment of a debt or another obligation, that would be a lien. So a lien simply is a right you give on your property to another party to sell that property, and as an obligation to a debt. So with liens, there's always a debt due, and the property is made collateral for payment of that debt. And a good example would be a mortgage lien. When you get a mortgage lien, you tell the lender that they now have the right to force the sale of your property if you stop paying them. That's called foreclosure. Someone who sells property is exercising the property right of disposition. Remember, those are your rights as an owner. You have the right of control, enjoyment, disposition, exclusion. Okay, those are your rights as a property owner. And your right of disposition is the right to convey the property. No one can sort of stop you from doing that. No matter when a property tax lien is placed on property, it will always be paid before any other taxes when the property is sold. So property taxes are always the first lien on property. They always get paid first. And if there's a foreclosure sale, they'll get paid out of the proceeds of the foreclosure sale before anything else. And if there's no other money left, then all the other lien holders simply lose whatever money they lent. But property taxes always get paid first. Adverse possession, if someone comes and uses our property openly, notoriously, hostilely, and continuously for 20 years in Illinois, 20 years are a period of time, they can actually go to court and claim title to it, and the court may grant them title. It's sort of like legal stealing. What the courts are saying is, if you don't protect your property, if you don't look after it, if you don't keep dispossessors off your property, and you just ignore other people using your property, and they want the property, we'll give it to them. That's what adverse possession is. When considering an appurtenant easement, the land burdened by the easement is called the one that's burdened, that would be the servient tenement, and the land that's benefiting would be the dominant tenement. An attachment lien is intended to prevent transfer of property pending the outcome of litigation, and it may involve the notice of lis pendens, to serve notice to potential buyers that there's a lawsuit pending. What we're saying here is a lis pendens is a document that is filed in the public recorder's office that gives notice to the world that there's a lawsuit pending on this property, and may, if the plaintiffs win, result in the loss of property. So it's a red flag to potential buyers. Buyers, don't purchase this property till you find out what happens with this lawsuit. Because if you take title to it and the plaintiffs win, guess what? You lose the day after, whatever period of time after you purchase the property. So lis pendens means lien pending. A lis pendens is a red flag to buyers on property. So one of the first things you'll want to do, and you don't do what the title company does, but one of the first things you'll want to have done, Mr. Buyer, is make sure there aren't any lawsuits on this property before you sit down and give your money and take title to it, get a deed to it. Make sure there's no outstanding liens that you don't want. There's no easements that you don't want. There's no lawsuits on the property that may result in loss of title. There's no encroachments on the property that you're not familiar with. You'll want all that done. That's the purpose of title insurance companies, by the way. They do all that for you. You as real estate agents don't have to do that. You as the real estate sellers or buyers don't do that. We hire title companies to do all of that investigation on title. An encroachment is a physical object which intrudes onto a neighbor's property. And as we said, encroachment, a good example was the fence that would be put up on somebody else's property because we weren't careful about our boundary lines. Maybe your neighbor puts a garage right on the property line between you and him, and the garage roof extends over into your property. That would be an encroachment. Sometimes you get trees that encroach. Their limbs encroach on one side, and sometimes their roots can go under the ground and encroach onto your property. Those are unlawful physical encroachments on another's property. True or false? A mortgage is an example of a voluntary specific lien. Yes, because you voluntarily go to the lender and voluntarily let him put a lien on your property because you want the money that they're going to give you as a mortgage loan. And it's a specific lien because that mortgage lien only attaches to a specific parcel of real property. It doesn't attach to any other real property. It doesn't attach to any personal property, like general liens do. General liens are the scary liens, like property tax liens. Okay, if you don't pay your income tax liens, IRS liens, if you will, you don't pay a court-awarded judgment. Those become general liens. which affect everything you own, all your real property, all your personal property. So the general liens are a lot more scary than the specific liens. An easement is an interest in real property that terminates when the property is conveyed. No, it stays on the property. So if somebody goes to buy a parcel of property, you better be aware of any easements that are on that encumber that property, because they're going to apply to you as well when you purchase the property. A license can be assigned and is not terminated by the death of the licensor. No, as we said, a license terminates upon the death of the licensor. It also terminates on the death of the licensee, okay, the person you gave the license to. So the giver of the license, licensor, the receiver of the license, licensee, that license will terminate upon the death of either party. And as we said before, if you gave your buddy a license to hunt, he can't assign it to somebody else. All liens are encumbrances, so that would be false. All liens are encumbrances, but not all encumbrances are liens. That's true. All liens are encumbrances. But encumbrances include more than just liens. Encumbrances can be easements. Encumbrances can be restrictions. Encumbrances can even be encroachments. Okay, they all can encumber a title in addition to liens. So while all liens are encumbrances, there are more encumbrances than just liens that can affect title to property. An easement in gross benefits a person or company, not another piece of land. That's sort of true. An easement in gross is a utility easement, so it benefits, say, the utility company, the electric company that put the electric lines across your property, or the cable company that brings cable TV to your property. When that property is, let's say, first developed, the builder might negotiate with the utility companies and the water companies to bring service in. And when that service comes in, that creates a lien on that parcel. And the lien holder is that utility company or the cable company or the telephone company, if you will, in the old days of telephone lines. And so that's called an easement in gross because it's on one parcel. There's no other parcel involved. Continue on to the terminology review for Lesson 4.